Welcome back. So, we're talking about appeal and what it means to appeal an eviction judgment. And today we're going to talk about a very specific term in the law, and one that a lot of people without experience in this area of the law get wrong. And it has to do with the term de novo and what that means. And so, when a case is appealed from the justice court to the county court, it's what's called an appeal de novo. And essentially, what it means is it's a brand new case. It's as if the case were being heard for the very first time. And, so many times clients want to point back to what happened in the justice court and say, well, Judge so and so said this, and I've already won this. But that's just not the case. And so an appeal de novo essentially erases anything that happened in the justice court. So if it happened with the justice of the peace, it's as if it didn't happen. And so you mentioning it is really a waste of time, because it's not a matter of efficiency. It's not a matter of, well, Your Honor, these issues have already been settled. Don't worry about making a decision here, because that's just not true. The appeal essentially means nothing is settled, nothing has been decided, and there are no winners or losers from the lower court. And so it's important to know that when you're presenting your case, it's as if you've never presented it before. You have to start from scratch. So your appeal requires that you prove again that you are a landlord entitled to possession, and that you delivered a proper notice. And so if you are relying on the justice court to prove your case on appeal, unfortunately, the court's not going to allow that. And so you need to frame your argument again, which is why it's helpful to have an attorney with you, because the attorney is likely experienced in landlord-tenant law and knows how to present these cases to the court on appeal. Because the truth is, all of the justice courts are going to handle things a little bit differently. And on appeal, because the judge is hearing it for the first time, it really doesn't matter that Judge so-and-so allows this kind of notice to vacate, and this other judge allows these kinds of issues to be discussed during the eviction trial. None of that matters, because you're hearing everything again for the first time. So don't go in with the misguided presupposition that what happened in the justice court is going to continue in this court. It's just not the case. And so many times I've seen plaintiffs get in trouble hearkening back to things that happened. Well, you said this at that court, or you didn't bring this up back at that court, because it's not worth mentioning, because again, it doesn't matter. And if you insist on raising issues that were purportedly decided by another judge, you're actually likely going to upset the current judge. So your key is to stay focused, present the case again as though nothing happened in the justice court, and prove your facts. And if you're able to do that, you should be successful.